I would request Mr. Parijat Kishore to please felicitate um, Learned Senior Advocate Mr. Sadan Farasat. I would request Ms. Rohini Wag to please felicitate Ms. Shelly Bhasin, partner, Merchant Mangal Das. I would request Mr. Amol Nehru to please felicitate Mr. Abhishek Rastogi. Honorable Mr. Justice Atul S. Chandrukar, Judge Supreme Court of India, Learned Senior Advocate Mr. Sadan Farasat, Ms. Shelly Bhasin, Partner Sadul Amarchand and Mangaldas, Mr. Abhishek Rastogi, Advocate, and all the distinguished delegates. Good afternoon. Welcome to this session on the Supreme Court roles in shaping the public policy regulation in India. This topic sits at the heart of the modern constitutional adjudication. How far courts should go in reviewing policy choice and how far they must go in the protecting rights and fairness and the rule of law. We are privileged to have Honorable Justice Atul S. Chandrukar, Judge, Supreme Court of India, and we are also having our scholar. And we are also having Mr. Sadan Farasa, Senior Advocate, known for the matter at the intersection of constitutional and regulatory law. Mr. Farasat is having a senior. Mr. Farasat is a senior advocate with nearly 20 years of advocacy experience, with a practice spanning constitutional, criminal, and commercial, regulatory, and civil law. I have to run through this because Honorable Justice Atul S. Chandrukar has to rush to catch a flight because this session has started late. So please excuse me for the introduction. I have to keep it out. But still, sir. Mr. Abhishek Rastogi, widely recognized for the constitutional work in the fiscal tax and regulatory domain. Mr. Rastogi is practicing advocate before the Supreme Court and various High Court tribunals and is well known for articulation and presence of mind in court. He previously served as equity partner with the Khaitan and Company and has an overall experience spanning 22 years with Ernst & Young, PricewaterhouseCoopers and Khaitan and Company before starting his own chamber. We also have Ms. Shelly Bhasin, partner Shadul Amarchand Mangaldas, bringing the perspective of the complex regulatory and policy implementation. Ms. Shelly Bhasin is a partner at Shadul Amarchand Mangaldas and is listed as a speaker for this session on public policy and regulation. Her presence adds the practitioners and firm's advisory lens to policy shaping, how regulatory design is experienced by the market institution and litigants. I would now request my lordship to please.
Good afternoon, everybody. Good afternoon. It's a pleasure that we also have Justice Joseph today. All distinguished members of the bar present today. It's nice that we're having back-to-back sessions, and all of you, I can see, are enlightened by the earlier sessions which you attended. At the outset, I would just apologize for having being required to leave a bit early because of my commitments, but we'll try to make the best of it. We have got a nice team of speakers to share their views with all of you today. Today's topic is also quite interesting, which is role of the Supreme Court in shaping public policy and regulation in India. What I propose is I'll just briefly divide it into about sub-parts. First is role of the Supreme Court in laying down the foundation through its judgments that has resulted in framing of policies and laws in India. Then the role of PILs, that results in change in the public policy. Then again, there is expansion of the constitutional rights, that is recognition of various constitutional rights and liabilities, which then leads to framing of policies and regulations. The other head is monitoring and oversight through continuous mandamus. That has also resulted in some regulations being put in place. And last one is filling in the vacuum through various enactments through experience. Coming to the first subhead, that is the cases that have laid down the foundation for policies and laws in India. It can be said that from time to time, the Supreme Court has stepped in and made various suggestions to the state through its decisions when it notices that its field is either unoccupied or there is a need to streamline certain issues that leads to framing of policies and on subjects which affect the public at large. Earliest judgment which we can recollect is that in the case of Ramesh Thapar, that is in 1950, where there was a ban on the media outlet in then Madras, which had criticized the actions of the government under the Madras Maintenance of Public Order Act. Now, Section 9(1)(a) was struck down by the Supreme Court as declaring it to be violative of Article 19(2), and this led to the First Amendment, whereby reasonable restrictions came to be introduced in the right to freedom. This has significantly impacted our understanding of the right based on reasonable restrictions from then on. One may refer also to the case of Husainara Khatun with regard to under trial prisoners, the plight suffered by them that led to observations being made and directions being issued that resulted in framing of policies. So, right to speedy trial came to be recognized as a fundamental right. Even after this judgment, on various occasions, there has been suo motu cognizance taken of various issues arising from the said decision, which has led to formulation of the Model Prison Manual. And this is considered by the under trial review committee from time to time, and suggestions being made are being acted upon. Then we have the case of Unni Krishnan, that is in 1993, which recognized education as a part of right to life, which then led to Article 21(a) being brought in. One interesting case having effect on the lives of those from the reserved communities is the case of Kumari Madhuri Patil, because the issue with regard to benefits being misused by persons not belonging to such categories was drawing the attention of the courts. So this decision in 1994 led to streamlining of the procedure for verification of caste claims, and ultimately, insofar as state of Maharashtra is concerned, the Caste Certificate Act of 2000 came to be implemented. This further resulted in various other states following suit, and then various office memorandums being issued by the central government in the matter of verification. Then we have the case of Vishaka in 1997 concerning female employees and the difficulties faced by them at workplaces. This decision thereafter has been taken further, and we now have a statutory enactment as well as various regulations in place which ensure that all are treated equally, even at the place of work, without any harassment of any type. Yet another decision which I could refer to is in the case of Tehseen Poonawalla, that is in 2018, with regard to the issue of mob lynching or mob violence. This has resulted in guidelines being laid down, which further became part of policies by the states to ensure that adequate protection is given and that there are no victims of mob violence or mob lynching. In the case of Mahinder Chawla, the need for having witness protection was the issue. The stakeholders and players in the criminal justice system would admit that this decision has led to a policy with regard to witness protection, which has now become quite successful. Another decision is in the case of Shakti Vaini with regard to honor killings. This has also taken the rural area to a safer regime, and aspect of honor killing which was haunting the traditional rights of the society, that came to be ameliorated. Then we have the case of Sita Soren, so far as the public policy on accountability and maintaining ethical standards in legislative functioning. Members of parliament and members of the state legislature, the code of conduct to be followed by them was the subject matter. This led to the regulations being put in place in that regard. In a recent decision in Yash Developers, the issue with regard to slum development, that was the subject of focus. It was noticed that slum development, though generated voluminous litigation, this resulted in hardship being caused because at various tiers, the people living in the slums were not getting relief. So what the Supreme Court has done is that it has thought it necessary to direct a statutory audit to be undertaken to ensure that the delays are reduced and reliefs are received by the people living in slum areas. Another issue is with regard to street vending, because this, it was found that it was totally unregulated, and in the case of Gaindaram, that is in 2010, the dispute with regard to regulation of street hawking, which started from Delhi and then was taken to various other cities and states, was the subject matter. The confluence with Article 19(1)(g), right to carry on trade, that was harmonized, and rights of street vendors were sought to be protected by putting various schemes in place. There are various decisions on this aspect, and I can just refer to a recent decision in the case of Anirudh, that is, I think, just about 15 days back, when the misuse of the provisions of the Protection of Children from Sexual Offences Act 2012 was noticed by the court, and it was observed that the legislature could consider introducing a Romeo-Juliet clause in that litigation, so that genuine relationships could be removed from the clutches of that enactment. Now, insofar as PILs are concerned, all of you are aware that through this mode of litigation, the Supreme Court has time and again stepped in, and while expanding its sphere in that regard, the rigors of locus standi have been slightly watered down, in the sense that broader outlook has resulted in genuine issues being focused upon, and this has resulted in taking the environmental issue as well as the issue of pollution further, and creation of awareness in that regard. Now, so far as expansion of individual rights under Article 21 are concerned, based on the decision in Puttaswamy, where the right to privacy has been held to be a fundamental right, various laws dealing with those issues, such as the Data Protection and Technical Regulation Act or the Personal Data Protection Act 2023, and the rules have been put into place. All these fields were unoccupied for a long time, and this has resulted in the legislature stepping in pursuant to the nudging by the Supreme Court or its attention being drawn to fields that are unoccupied. I think this can take the matter forward.
Thank you so much, Honorable Justice Chandorkar, for the very insightful and very thought-provoking ideas about this whole aspect of the public policy. And it was very interesting, like to hear all. I would now request Mr. Shadhan Farasat to please. Yeah, because, my lord. So, yes, sir, I'm so sorry because we are kind of flash. Just a second, sir. So, I would request Mr. Abhishek Kaushik to please come on stage and to felicitate Honorable Justice Chandorkar with the memento. Sir. Yes, sir. I mean, there is no pressure, sir, because. Okay. So I would now request the learned senior advocate, Mr. Shadhan Farah, sir, to please come on the dais and deliver his address. Yeah.
Thank you, Kaustubh. I'll try to keep the introductory remarks very short, as Justice Chandorkar has to leave. So the topic, as you can see, is very broad, and Justice Chandorkar has quite craftily covered the entire area of social justice. So what I'm going to focus on is broadly the regulatory aspect of the Supreme Court's role. What does the Supreme Court do in a regulatory role? If you just look at it, one is, of course, Article 32, you have a lot of petitions coming in. That's one jurisdiction the court exercises. And then there is a whole bunch of regulators under different parliamentary enactments. And from each of them, there is an appeal to appellate authority, and then it straight away comes to the Supreme Court. We are aware of all of that: electricity, APTEL, Supreme Court; Competition Commission, Appellate Tribunal, Supreme Court. Then you have TRAI, TDSAT, Supreme Court. And there is a whole bunch of it, about 7, 8. Even NCLAT, which deals with NCLT, NCLAT, then Supreme Court. The crucial point there really is that the high courts are really out of that regulatory jurisdiction. It straight away comes through appellate tribunal to the Supreme Court. And that's in a way very defining, because normally high courts act as a buffer for settling the law in between the Supreme Court and the lower courts, and that buffer really is absent. So in that sense, the Supreme Court's role is even more remarkable and more important. And when we look at that, the normal framing of the question is judicial overreach versus legislative absence. I mean, that's the way both sides of the spectrum are put forth. I would suggest that that actually may be, in a certain set of circumstances, true. But really what in most of these cases the Supreme Court is doing is actually trying to correct regulatory failure. It is correcting regulatory failure in two ways. Once, if there is effectively a over-regulation, and second, if there's under-regulation. Now, over-regulation cases are effectively something like, I'll just give an example from a recent example from SEBI-SAT case. There's a Jane Street case which is pending before the Securities Appellate Tribunal presently. There what happened is that SEBI, without giving a hearing, without actually making any determinations ex parte, banned a particular trading entity from the market and imposed a fine of 5,000 crores. Now this is ex parte ad interim stage. It's obviously a very, very consequential order. SEBI otherwise has an extremely good reputation as a regulator, but this is possibly one of those cases of overreach, which has to be corrected. Presently, pending before SAT, it may or may not come to Supreme Court subject to what happens. But that's a classic case where the Supreme Court may be asked to set the doctrine or the levels and at what stage what you can do. Because all these cases, once the doctrine is set at the Supreme Court level, day-to-day litigation on that doctrine happens in the appellate tribunal and the base forum. It doesn't every time come to the Supreme Court. So that's one area where over-regulation, it's an example where over-regulation will be tested and corrected and doctrine set. Cases of under-regulation are many, and there also the Supreme Court comes in to correct error. Electricity cases are classic examples. All of us know state commissions, broadly, I mean, they function along with the state government's intent. They are technically supposed to be independent, but state electricity regulatory commissions, because tariff is such a politically sensitive issue, tariff is something which impacts consumers at large. State governments and central government is very sensitive about tariff issues. So therefore, there are informal pressures on the SERC in terms of how it goes about setting the tariff. That's another case where you have a situation where the Supreme Court needs to step in and say, no, you're not really doing your job as a regulator, you need to do it correctly. And recently there was a judgment of BSES by a division bench where they said that you actually have to reflect real-time cost in tariff settings. You can't just keep it pushing the can down the road in hope that somebody else will pick it up. You have to do it in a very streamlined, timely manner. So that's one case where it's there. Then third, I would submit is just look at environment and pollution. That's a case where, I mean, we are actually breathing bad air in Delhi. We are so happy we are in Goa because the air is clean. I think I speak for everybody. But what we are breathing is not just bad air, we are actually breathing in regulatory failure. Because what has happened there is you have a whole bunch of authorities in National Capital Territory and around who have not been able to come together and act to get this, get the whole air pollution situation under control. And there you, in 2021, that was also under Supreme Court, sort of some kind of informal pressure, you had a CAQM, which is Central Air Quality Monitoring System, which was established. And that was to basically have connection between all the different areas of NCR, not just Delhi, but the affected districts in neighboring states of Haryana, Uttar Pradesh, and Rajasthan. And they have, I mean, there's a parliamentary act, it does have, all this GRAP 3, GRAP 4, they implement it, which we are aware in Delhi. But even today, air pollution situation is not in control. And so I would argue those are the kind of cases where the court can really set the policy narrative much more aggressively. It impacts so many people at a large stake that there is a lot of space. In fact, the government may initially resist it, but eventually when the things are corrected by the court, I think the governments themselves are very thankful to the court that they actually did it, because governments have so many constituencies to deal with. They don't want to make them unhappy, but the court is sort of functioning as an independent institution. It really has that ability to set the corrective measures. But the area where I think the court is normally very circumspect is when individual cases come to it and it is making a direction in respect of them to do something, for instance, if something is not being investigated. Normally, I think the court is very circumspect to go into it and say, you investigate this person in this manner. But in some cases where there's complete regulatory sort of failure and there's, you can even say regulatory capture, you can see that the entity is not being examined because they possibly have some influence. In those situations, of course, the court comes in. I think why the court is very circumspect, and rightly so, in most cases, is because if the court were to direct investigation and monitor it, then if there are errors, where does that individual go? Because actually, we as lawyers always come to court when the investigative agency is wrong for the person. But if the court is monitoring and directing that, you really have no place, and especially if it's a Supreme Court. So I think it's normally very circumspect. In fact, the errors also, I would submit respectfully, errors also happen when in those kind of cases, sometimes the court goes overboard. And that's where people have no remit, I mean, that individual agency, corporate, individual, whatever it may be, really has no place to go. So I think that's where those errors occur. And broadly, I would just frame it as a question, not therefore, of policy overreach versus testing versus filling in the legislative gap, But I would just say that the Supreme Court really acts as a repairman for regulatory failure. So those are my introductory comments. Thank you.
Thank you very much, Mr. Sadhan Farashid, for sharing your views and enlightening all the audience. I think Mr.
I just make a strange request. We have Justice Joseph today, so I'm required to leave because of some commitment. I would request him to kindly chair the and take it
Yes, sir.
forward.
It will be really nice, sir, to have you. So, we have with us now our former and most loved, our former judge of the Supreme Court, Mr. Kudan Joseph. So, before moving further ahead in this session, we all obviously wanted to have your views also, sir. Something, whatever, sir. I mean, final words, okay, sir, done. Sir, you can speak any time on any topic. We all know about it. So, okay. So I would request Ms. Shali Bhashin to address the audience. Thank you.
Good afternoon, Justice Korean and friends. Justice Chandurkar and Shadan have already covered a lot of it. I just want to say a few words here. While policy formulation and implementation lie primarily within the domain of the legislature, the judiciary, and in particular the Supreme Court, occupy a unique position as interpreter and guardian of the Constitution. This role has inevitably placed the court at the intersection of law and public policy. Over the decades, the Supreme Court's engagement with public policy has been marked by a constant interplay between restraint and intervention. On the one hand, the court has repeatedly emphasized institutional limitations and the need to respect democratic decision-making, especially in matters involving policy formulation and technical expertise. On the other, when confronted with legislative vacuum, executive inertia, or structural violations of fundamental rights, the court has not hesitated to issue directions that significantly influence or even shape regulatory and policy frameworks in India. This continues to provoke debate on judicial activism, separation of powers, and democratic legitimacy. The Supreme Court has consistently reiterated that courts are not policy-making bodies and should not substitute their judgment for that of the executive or legislature. Judicial review, in principle, is therefore limited to examining the legality, constitutionality, reasonableness, and procedural fairness of policy decisions. This approach was reaffirmed in 2023 in the Air Commodore N.K. Sharma case, where the courts held that tribunals cannot direct the executive to frame or amend policy. The decision reflects a broader jurisprudential trend emphasizing institutional competence and democratic accountability. Courts have not hesitated to admit that policy choices often involve complex considerations, economic, technical, and political, that courts are neither designed nor equipped to adjudicate. As early as in 1994, in the Tata Cellular case, the court has set the precedent that judicial review administrative action does not permit courts to sit and appeal over policy decisions. Such decision underscores the court's awareness of the dangers of overreach, particularly the risk of transforming judicial review into judicial governance. While the primary principle in policy-making decisions is for the judiciary to exercise restraint, one cannot deny that the Supreme Court's role is that of a protector of fundamental rights. It is this dual role that the Supreme Court plays that has activated its indulgence of policy-related matters. This shift became specifically pronounced as the court identified the need for and developed the process of public interest litigation. A defining moment in this trajectory was the Vishakha judgment in 1997. Faced with the absence of legislation addressing sexual harassment at the workplace, the court framed detailed guidelines grounded in constitutional guarantees of equality, dignity, and life. These guidelines operated as binding law for over 16 years until Parliament enacted the Sexual Harassment of Women at Workplace Act in 2013. This case reflects a model of judicial intervention justified by three recurring factors. The presence of fundamental rights violation, second, prolonged legislative or executive inaction, and third, the necessity of interim safeguards to prevent constitutional harm. The Supreme Court's influence on public policy has become even more pronounced in the context of technological changes. It was the lack of an expert adjudicatory body that could deal with issues related to technology, privacy, and data regulation that gave courts a foundational role in determining the trajectory of this area. In case Puttaswamy, the court recognized the right to privacy as a fundamental right, intrinsic to life and personal liberty. The judgment highlighted the need for specific laws for data protection and regulation. This has directly shaped India's data protection discourse and regulatory architecture with the implementation of the Digital Personal Data Protection Act 2023. This balanced approach underscores court's determination to ensure that court maintains its approach to be that of a norm setter and not a rule maker or a policy maker. However, ongoing proceedings such as Ranveer Allahabadiya case reveal the challenges inherent in digital content regulation. Judicial observations on obscenity, morality, and online speech often act as normative signals to regulators and lawmakers, influencing policy direction even if the court refuses to pass explicit directions to that effect. The Supreme Court's engagement with public policy has not been confined to traditional state functions. In BCCI versus Cricket Association of Bihar, which is an ongoing matter, the court undertook extensive oversight of cricket administration, restructuring institutional governance through committee-driven reforms. These directions reshaped accountability, transparency, and conflict of interest norms within Indian cricket. With such judgments, it appears that the court has evolved into governance courts and has crossed the line of being merely an adjudicatory body and protector of fundamental rights. It has now started to actively shape institutional design. Another manifestation of judicial governance is visible in the ongoing litigation concerning the stray dog menace. Through continuing mandamus, the court has issued operational directions to municipal and state authorities, monitored compliance, and effectively shaped urban animal control policy. While these interventions are driven by concerns of public safety, animal welfare, and the right to life, they also highlight the tension between adjudication and administration. Continuous judicial monitoring blurs institutional boundaries, raising concerns about accountability, expertise, and the absence of clear strategies. To conclude, it is understandable that any decision of the Supreme Court which delves into policy formulation draws criticism, specifically as it gives more ammunition to the legislature to shift accountability, disincentivizes legislative action, and risks undermining democratic legitimacy. This concern is particularly fraught in cases where courts pass sweeping directions instead of setting up interim guidelines for the legislature to act upon. However, judicial intervention cannot be delegitimized on these grounds alone. It is undeniable that more often than not, courts have intervened and stepped into the role of policymakers where there was a glaring legislative gap. Their decisions have ensured protection of rights of those vulnerable groups which till then did not get a political voice. Accordingly, it's not an aberration but a constitutional necessity. Specifically, when such judicial intervention is cognizant of the fact that it has to be interim, anchored in protection of rights, and paves ways for future concrete legislation, such as in the case of Vishaka and Puttaswamy, it ensures implicit acceptance of such directions. From workplace safety and sports and privacy to sports governance and digital regulation, judicial review has often acted as a catalyst for policy reform, whether viewed as judicial overreach or constitutional stewardship. The court's influence underscores a distinctive feature of the constitutional framework in India, that is, the judiciary's willingness to intervene where governance failure threatens fundamental rights. Thank you.
Thank you so much, Ms. Bhasin, for your address to the audience. I would now request Mr. Stogi to please come on the dais and address the audience.
Sir, sometimes when you are arguing last in the batch of petitions, it is very difficult because the judges would always tell you, we do not want any repetition. the life becomes more tough when you are arguing and you know that after 10 minutes there'll be lunch break and the court is not sitting in the second half. So keeping both of these factors in mind, let me try to make it a little interesting, and I must make full disclosure that these cases which I am referring, I had appeared in these cases. But let me emphasize on the role which Supreme Court plays. And a lot of times when these questions come with respect to policy decision, the first and the moot point is whether these policy decisions are subject to judicial review and what is the provision which has been challenged. Is it manifestly arbitrary or not? And coming back to where I started, I was arguing one of these matters where the notification was challenged, the statutory provision was challenged, and more than a dozen of senior counsels, and you name the senior most, were all there. And of course, I was there last in my turn. And after the matter was argued for more than 7 days before Justice Chandrachud, the learned ASG said that what Mr. Rastogi will argue now, my lord, because 7 days it has been argued, so maybe, he can file written submission. And sir, you would not believe, I made that statement to Justice Chandrachud, and I said that, my lord, I waited for my turn for 7 days. I heard all of these seniors for 7 days, so at least I may be given 10 minutes to argue. He said, no, Mr. Rastogi, we'll hear you patiently. We give you half an hour to 45 minutes, please take your time. So that's the role, when even Supreme Court, even when we are not that senior, but we are given that opportunity. And the issue was very critical for the entire importing community in India, the entire exporting and importing sector. And after the arguments, Supreme Court said that this provision is certainly unconstitutional. This notification is completely unconstitutional. And I got the compliment that your 30 minutes have emphasized on those points because we deliberately told you not to repeat on those aspects which were very important. And perhaps to me it was one of the most simplest thing to argue that how could you have double taxation for a composite supply? And Mr. Salve called thereafter and said that this point was completely missed. What you raised will change the direction of the judgment of this. It was some 200 pages decision. And I think the role of the Supreme Court is not only, to address these issues, but also to give fair opportunity to the counsel. So I think that was a good learning. You have to, even if you're last in your turn, you have to be very, very sure that what points you want to put forth because time of the court is very important. The second experience which I would want to share, Justice Pankaj Mittal also mentioned about the balancing act which Supreme Court plays. And when these matters on policy issues are coming to the court and the constitutional validity is challenged, sometimes court takes those views which are very pragmatic. So in Cosmo Films versus Union of India, when we were arguing before the Supreme Court and we were very high on confidence because Gujarat High Court has already held pre-import condition to be unconstitutional. And we then realized that Justice Bhatt is now posing some very interesting questions. And these are purely on the constitutional aspect. That why you want this condition to be treated as manifestly arbitrary. He wanted us only to argue on the constitutional part. And the flavor was very clear. That he would now say that this condition is constitutional. But the court, in the most pragmatic way, maintained a balance. The court said that yes, this condition is constitutional, but the Indian businesses must get the benefit. And hence, either by way of credits or by way of refund, each business must, who has legitimately done or performed the transaction, must get the benefit. So I think these are important pragmatic ways by which courts have addressed this. My third example is where we represented before the Supreme Court in case of Safari retreats case. There was already an order from Orissa High Court. The provisions were read down, and when the matter came before Justice Oak, he raised an issue that you divide your entire submissions in two parts. One on the constitutionality and second on the interpretation. And of course the order came, and it was a detailed order which completely changed things for businesses in terms of these provisions. And it was to our surprise in the order that while he said that the provisions are constitutional, and I'm again coming to the point that how Supreme Court maintains a lot of balance. Supreme Court in this decision said that we would want the entire controversy to be determined based on two tests: functionality test and the essentiality test. This matter was argued again for several days, both on the constitutional part and on the interpretational part. But the judgment went into a fine balance that legitimate business must get the benefit, but we would want to retain the constitutional aspect of the provision. But at the same time, we would want these businesses to cross these tests of functionality and essentiality. So it became very clear that when Supreme Court is pronouncing decisions on a lot of these issues, they would not only want to maintain the balance, but when it comes to the question of public policy, whether this aspect is absolutely manifestly arbitrary or not, whether you're making that case or not. A lot of times questions of alternate remedy, etc. also come into play, which I'm not getting into. But that balance which I think our courts have maintained really helps. The last one which I want to share where with respect to Supreme Court decision was with respect to the transitional credit when this great reform of GST happened. And we got the order from Delhi High Court, revenue challenged before Supreme Court, and the first day the revenue made the statement was that if this is allowed, 100,000 taxpayers in the country will get the benefit, the revenue stakes will be huge, this matter needs to be heard. And of course, 100,000 people would get the benefit, court was not bothered. Court said that even if 100,000 businesses will get the benefit, we would want you to prove that why we must not follow this order of Delhi High Court and why we should interfere. Because according to us, this is a vested right. And somewhere the body language or the tone of the Supreme Court was so clear that the matter was never argued. They went back to Ministry of Finance, they took instructions and they said that yes, this is an error. The result must be beneficial to businesses, and without, I think, the decision of the Supreme Court, 100,000 people got the benefit. I think that was the tone of the court because the court was very clear. We don't care about 100,000 taxpayers getting the benefit or not, but we would want to get into the merits and why we should interfere. And how this helps, how this role of Supreme Court helps all across the country is because it sets the tone. It gives the direction. And that is very important. And that's why when we get these orders from Supreme Court and when we argue on a lot of other issues in High Court, we use this directional clarity. So I was arguing one matter before Bombay High Court, which, relying on some Supreme Court decisions. And there, the issue was legitimate expectancy. And huge amount of investment has happened. And the question was whether the business could have legitimate expectancy or whether the principle of promissory estoppel would come in for a tax provision. So what equity, etc. was all before the court. And when you have more directional clarity from the Supreme Court judgments, even it is easy for us to argue before the High Court because that aspect is important. And Bombay High Court said that while we would want to decide even on the principles of promissory estoppel on this case because there was an investment based on some promise made by the state, the matter was argued in such a way that the state government told Maharashtra Tourism that this benefit must come. These changes must come. This is in the larger public interest. These benefits which have come, or these investments which have come in the state, are for larger public benefits, and hence we must not discourage that. The last one which I would want to share, and so this is very interesting. For a lot of these matters, one, when these authorities today, we know the role of EDs and DRIs and customs, everybody issues summons. And these summons are sometimes traumatic, and sometimes people are taken into judicial custody, not because of the offense, but because of non-appearance for these summons. So we have taken these matters to the court, where we are saying that what is the need for issuance of these summons, if there is a cooperation, first of all. And there are several decisions of the courts now, that these summons must be quashed first, unless and until it is proven that there is a case of non-cooperation. The related aspects are the coercive recovery, and also what happens sometimes is that maybe some company would have done something wrong, and in one case which we argued before Bombay High Court and it went to Supreme Court, there is a penalty on the CFO of the company, and that penalty was 3,000 crores. 3,000 crores. On a chartered accountant who would have a salary of perhaps 1 crore, was imposed a penalty of 3,000 crores, and the court very categorically said that the principles of proportionality will come into play. So of course, Supreme Court upheld that order of Bombay High Court. So I think Supreme Court gives a lot of directional clarity, not only to us, to businesses, but also to different courts. And I think from that perspective, whenever these matters on constitutionality and public policy are going to the court, that aspect remains very important, and we are glad to have such a system.
I came uninvited, so I thought I'll speak uninvited also. I came and sat in this hall when the people on the audience stepped to the dais. There was hardly anybody in the audience, so I thought I will be an audience here. So somehow you people saved and had some grace. This subject I was just reading, Supreme Court's role in shaping public policy and regulations in India. Probably if you had asked that Bhadra to speak on this, probably she would have spoken. She has seen over 3 decades. What is this? You should have asked Dhananjay Mahapatra to speak on this. He would have spoken. You should have asked Krishnadas to speak. These are the people. Who was Krishnadas senior? Bhadra? Venkatesh. Yes. So those are the people who have seen the Supreme Court actually, how it acted as guardian, how it failed to act as guardian, how it was reluctant to as guardian, how it, yes, all this they have seen. So they would have actually spoken far better than any one of us, because we speak out of our compulsion on, but they speak out of their constitutional conscience. So that is the whole difference. I was just wanted to make a first comment on this aspect. Secondly, is the Supreme Court meant to shape a public policy? What is public policy? What do you actually mean by public policy? You spoke about numbers, not 10,000 taxpayers. You spoke about you also spoke about the, what they call, even when the regulatory mechanisms are there, then even then, some other agencies come and take over those jurisdictions also. Because if you have a regulatory mechanism under the Companies Act, you have a regulatory mechanism under the Income Tax Act, you have a regulatory, because all your defaults do not necessarily become a white collar thing. If you want to make it white, you can make it white. You can, if you want to paint it as black, you can paint it as black. So those are areas I thought they should have some sort of a policy guidelines issued by the court. Being a guardian, what's the purpose of guardian? Or who guards? Guards what? Guards the Constitution. So what is the Constitution meant for? Constitution? We the people of India, having resolved to constitute India into a sovereign, secular, socialist, democratic republic, and to secure to its citizens. Secure to citizens what? All these things: justice, equity, this is equality, liberty, and fraternity, assuring the dignity. So when the assuring the dignity the assured dignity of the individual fails, only there the guardian should bark and sometimes bite also. That's the guardian's role, because guardian always has to guard the asset given to its care and protection. But when it fails to bark and if required to bite, then the constitution fails. And if the constitution fails, then the asset goes. That is the whole problem. So it's actually not made, it's not actually meant to shape policy. It's actually meant to guard the constitution. That's the most important aspect. Policy is for them. And the court, by its fundamental or rather first principle, is not meant for a judicial review of public policy. There's no judicial review of public policy. There is only a judicial review of the implementation of the policy. And in the review of the implementation of the policy, courts will always see whether the constitution, whether the policy was constitutional or not. That's why always these great people who are sponsored here now, when they were holding the constitutional position, they would say it's a matter of policy. That means please don't intervene. All the top people were all the people who will be speaking this only. No? Once upon a time or once now, they are all meant to speak on that only. It's a matter of policy. That means please don't touch. So the court is not actually meant for overseeing the policy. Court is only actually seeing the constitutionality of the policy implementation. Because that's why the executive, the court does not oversee the executive. Court can only see oversee the executive action so as to review its constitutionality, not its defective policy or its perfect policy. No, that's not in the realm of this. So therefore, to me, if we call the Supreme Court as a constitutional guardian, then my last point, I want to speak to these lawyers also. You are also guardians of the Constitution. The only problem, when the bar stopped barking, the Supreme Court started declining. Thank you very much.
So actually, sir, precisely the reason I have requested personally to Ms. Bhadra to be here, I mean, in this, and to participate,
Now she knows where to sit.
and requested her to participate because nobody can ask better question than her, we all know. So yes, like the mic is over to you for these questions.
I totally agree with what Justice Joseph has said, that judiciary is actually, guarding what is there in the Constitution. But when we talk about Supreme Court's role in shaping, of course Supreme Court hasn't really shaped, but yes, it has definitely tested the policy, the government policy on the anvils of the constitutional principles. But what my question to, in fact, the panel is, because this is a question which I keep asking myself, I have been in and around judiciary since 1998, 99, and I have seen the way trial courts function, the high courts and the Supreme Court since 2007 and 2008. And I think 18 or 19 years down the line, what I personally feel is what Supreme Court was doing in 2007, it is just doing the same thing in 2025 as well. Just to give you an example, but you see the role of the Supreme Court becomes important, and in fact, it becomes important if only the judgments delivered by it are really implemented effectively, right? And why I really say this is because we came across the latest Supreme Court judgment in connection with the tribunals. And we have seen this issue being in litigation for so many years. I think it's been more than a decade now. And still we don't have any finality on it, right? Okay, of course the Supreme Court is there to test these laws, to see the effective implementation of these laws. But we are really, somewhere down the line, there is a gap when it comes to the implementation of Supreme Court judgment. Why is there so? Is it because the executive is not keen to follow these judgments? Or is it that the Supreme Court's intervention is too much, to such an extent that it is making the executive feel uncomfortable?
executive feel uncomfortable anytime at all. That's a $1 million question. See, Bhadra, to the question that you asked, as far as guardian is concerned, you know, we are all parents. I think 90% sitting are parents only. See, you may not always speak to the liking of your children. And many of the corrections that you give are to the dislike of the children only. Because children do not know what they ask for and what they stand for. But the parents know. Otherwise, that's why called they are parents or guardians. They're able to oversee and see, because they will only give what is good to the children. So therefore, one area where probably this policy shaping is, you referred to this Vishaga, I think Prakash was one case you left out, all of you left out, which went to that CBC Act. But for that policeman coming there, CBC Act would not have been there. Whether CBC is there or not is a different question, but that act came because of that rule. So, if there are areas where the executive conveniently omits not to legislate, maybe those are areas where the judiciary can always. That's how this Vishaga came. That's how these Prakash guidelines came. That's how that, what's that environment, what's that great man from Kerala who died recently? Godavarma came. Godavarma ruled the environmental law of the whole country for 3 decades. Even continued. I think that case is still there. Continue. It's a continuing mandamus, yes. So therefore, these are areas where the Supreme Court can always say, and also it's a settled principle, the judiciary cannot direct the legislature to make law. It can only point out that there is a lacuna. And now the courts have taken, used their wisdom, not only to point out that there is a lacuna, the courts have taken, gone to the extent of actually doing something till you do your duty. Till you do your duty, for you we will do the duty for the nation. So duty for the nation, when the court does, only problem is that it is never a debated one. Whether there is debated legislation now is another question, but all the same, the presumption is that there is a debated legislation because the public view, that's why it becomes public. Court is never meant to be a public's voice. Court is meant to be a constitution's voice. That's the only thing. So when the public speaks, it may not be a constitution speaking. The court can only see whether it is a constitutional shaping that is given in the policy. That is the court's duty always. So to the like or dislike, the court has always to say what the constitution is. Always. And particularly for the Supreme Court. It should be supreme in all respects. That's why I asked you, the bar, I'm telling you the bar, you must see that because judges will come and go. You, the bar, will stand forever. Just keep in mind. So therefore, the image, don't think it will depend only on the Chief Justice and the judges. The image will also depend upon the type of the bar that the court actually has. So show that stature of the Supreme Court bar. Show that stature of being a what you call a responsible lawyer, because under the Bar Council of India regulations, we are called, what is that called? We are called gentlemen. We are the only profession where somebody has called a gentleman statutorily. Not because we are gentle, because there is a presumption that we are a learned man. So that's my last sentence in the Supreme Court when I retired. The silence of lawmen does more harm than the violence of lawless men. This is precisely what is happening for the policy lacuna.
Sir, can I just add something? And it is also in the form of a question to you, that a lot of times it has happened that when the matters have even gone to the Supreme Court and validity of a provision has been challenged, and Supreme Court has held that a particular provision is unconstitutional, several times it has happened that there are retrospective amendments, which are retroactive in nature. And that defeats the complete purpose. Now, Supreme Court steps in, matter takes several years at the High Court level, matter goes to Supreme Court, and then you realize that after the decision has been pronounced, at the implementation stage, and which has been a subject matter of discussion as well, that how well these are implemented. Suddenly you realize that there is a retrospective amendment which is retroactive in nature. So I think that also then you go to the second round of litigation where then you are challenging the retrospective amendment and again going to the court for validity of that retrospective amendment.
On this retrospective amendment, the legislature was very circumspect if you look a little backwards. Because only on fiscal matters they made very seldom this sort of retrospective amendments. Now there's nothing because you may say anything, we will do what we want. And what we want, we will not test. This is the level. This is where it hovers on what Bhadra said, you have judgments but hardly implemented. So
Exactly.
it's not a question of you say what you want, but it's a question that that's otherwise there's no meaning in Article 142. The law that is declared by the Supreme Court of India will bind all the courts and tribunals across the country. Where does it bind now? Now they are going to say it binds only the courts and tribunals, not the executive. This is what is it actually meant for that? It's not actually meant for that. That means the law that is laid down by the Supreme Court is actually law declared. That is binding on the courts and tribunals across the country means it actually binds the nation. Not for a judgment, but actually for the public policy as well. But there is no such guidance or wisdom taken by the respect for the pronouncements also has eroded. I don't know. That's also a fact. It's a fact.
Just to answer Bhadra's question on the tribunals and the implementation. Yeah, no, I could see that, yeah. So I'm just, broadly, I think one area is that tribunals, as I see it today, there's a lot of dysfunction in tribunals, right? There's a massive dysfunction in appointments, you can see it. If there is appointment, the quality is sketchy, some are good, some are average, some are bad. So as lawyers, we can see it, we can only speak in conferences, but we can't, anywhere else say it aloud. You as
Is there a
journalists.
distinction between dysfunction and malfunction?
So you can say that. I can't. So, so there is, I think, a huge challenge. The way I think the executive reads it is, I think there is a feeling, at least in a section of the executive, that if the tribunals collapse, what's the big deal? Let them collapse. Let them collapse. Because at the end of the day, institutions have to maintain their own institutional credibility. It's true for the Supreme Court, it's true for the regulatory bodies, it's true for all tribunals. So if they're not credible, it's more power for the executive. That's the way I think there is a very underlying political reading of it, if it were. Sorry. Yes. So I think that's the way executives, and it's, I think, across the board, it's pretty much, even in states, you get to see signaling of the same kind of thing. Of course, at a smaller level because the powers are more limited. But I think the same kind of signaling is there. So I think that's why what Justice Joseph said, that following through on your judgments is absolutely essential. Because if the executive gets a sense that the courts are shying away from implementing their own judgments, then of course it's a free run. And then you really, a citizen has nowhere to go. So I think it's essential, and there are cases where sometimes I think the court has been more reticent than it should be in following through on its judgments. Of course, legal questions on retrospectivity, etc., can be argued quite legally. But once the law is settled as to how far you can go on a retrospective, fiscal legislation, non-fiscal legislation, the final word has been said, then just follow through. And that, as you, Bhadra, you know, and I think most in the room would also have that sense, it's very patchy. The Supreme Court's sort of follow through on that is very patchy. And then the executive reads that patchiness as empowerment for it. I think that's the way I would see it.
What is about the consistency also? Why don't you speak on these things also, consistency?
That's what my question is precisely, sir. Sir, my name is Vishnu Shankar Jain, and my question is that we are seeing that today different courts are taking different views of a matter. So we are discussing on the issue of Supreme Court's role in shaping public policy and regulation. But whether we should also discuss and debate on the issue that there can be a national judicial policy, so that if a court is, and the highest court of this country is taking a view of the matter, then ultimately we have to follow the procedure and it remains final. Because we are seeing that there are 17 Supreme Courts in this country and different courts are taking different view. So sir, how to go about?
It's not 17 at the given point of time.
Sir.
So you keep on adding, because
Sir. So, sir, how can we come over this issue and get unanimity and consolidation?
You know the root of this word constitution bench? Where does this come from? Constitution bench. It's in the constitution. There shall be minimum of 5 when interpretation of the constitution. So I think you, the bar, when you argue, you must tell the Supreme Court that this court is meant for interpreting substantial questions of law on the interpretation of the constitution, not simple this actually created a big problem in the Supreme Court not being supreme. Its supreme glory should be kept as a constitutional court, according to me. I think it's the eternal vigilance of the bar, not the vigilantism of the thing. It's the vigilance of the bar that's very, very, very important. It's actually the need of the hour, according to me.
I have a question because this is on the issue of dysfunction. Now, Mr. Farasat and Justice Joseph are especially experts on center-state relations. Now, the issue of federalism is actually something which is more policy-driven, but it's leading to constitutional conflicts now. Do you believe that the Supreme Court, as a policy and to guide policy, should actually look into legislation not as a balancing factor, not look at it that they need to balance issues, but actually enforce the federal structure?
Court is not actually enforcing, court is actually protecting the federal structure, because this country is, I have a, it's called something called federally structure, federally constitutional or constitutionally federal. This was my question once I asked to somebody. Is it federally constitutional or is it constitutional federal? It's actually meant to be constitutionally federal. But to protect it as federally constitutional is actually, because the executive won't do that. Because you know, when we started these alliances and the regional parties coming in, then you know, center ruling by one party and the states going to by regional parties, you know, then this whole problem started, you know. It's actually, if you study this issue, maybe the last, maybe 15, maximum 15 years, you know, this amoebic growth of regional parties, and that is actually meant to a lot of friction between the this state and center. I can ask you a simple question. You know, just read today's reading also. The what you call, you always read the news of the hour to understand the pulse of the people. This is the basic thing on journalists also. No? Is there any friction where the governor is in a state ruled by the center? Any given point of time? Never. Never. Why? Is it not a state? Is he not a governor? Is he not a federal unit? All are there. But why friction? Because the federal structure is not actually respected. If it is not respected, it should be protected by the guardian. That's why, you know, this is not the guardian saying that, no, I could have done it last year, but I'm sorry, but I'm saying it now. I should have said it long back, but I'm saying it now. There's no point in that. Guardian's role is always to, you know, to guard as and when things go wrong, it should set it right. That is actually the guardian's role. And if you fail to do it timely, then, of course, it affects the nation.
Yeah, just on Chitranshu's question. So on federalism, see, the original idea in our constitution was, of course, even Dr. Ambedkar and everyone were a little circumspect. We were coming from a national movement. We are trying to form a country. There was genuine anxiety on the question of whether we'll be able to retain it in one sense. The global view on our country was we will be dismembered in 10 years' time, right? So there was genuine anxiety amongst the constitution makers at the relevant time. So obviously you had a little bit more center focus. Now that's 1947, 1950. Today we are in 2026. I don't think there is any reason for that anxiety to exist. That anxiety, if anything, we have proven everybody in the world wrong, right? We have sustained ourselves as a federal unit for 75, 80 years nearly. In today's context, and I would say in last, say, 15, 20 years context, therefore, if the court is taking a non-federal positioning, I think that is effectively damaging the structure and the ability of units to govern. Because I don't see any reason apart from, you know, the effect of such positions effectively is you are already empowering the already empowered. You are empowering the already empowered. And therefore the balance shifts very much. So I think, and again, I think in constitutional adjudication, the text is the beginning point, correct? So if text is the beginning point of adjudication, it's always the view which the court has on federalism. If it's a pro-federalism bench with the same text, you will get one outcome. If it's a sort of not really, you're not going to put federalism as the meat of the question, then you will get another outcome. And that we have seen in a whole bunch of cases recently. But what I would argue is that I think the pro-federalism case in today's India is very strong when adjudicating. I don't think the constitutional text is a limitation. Because if you can always, as in constitutional adjudication, unlike a statute, it's not written in stone. So it's a question of how the court were to approach it. And therefore, it should actually, in today's India, it will help a lot if it's a pro-federalism approach which the court takes uniformly. And again, it's a problem which is arising in different questions, this question of fragmentation, right? There's so many different benches. How do you read what's going to happen? Is there a consistent view? That as lawyers we face, as everyone faces. I think somebody like Shelly faces, advising client, more client-facing side. What I was discussing with her yesterday. What do you advise your client on what the Supreme Court will do on this? Is it possible to advise a client on what the Supreme... It's impossible advice to give. You will always have to caveat it with 3 different caveats. So that's a challenge we all face. And therefore uniformity is needed. Certainly in these kind of larger questions, you should have uniformity.
Just to add here, I really believe there is a need for consistency, as you said, sir, today. That is the key word today, and which is really lacking in the Supreme Court today. As somebody said, we have 17 Supreme Courts, and we face, all of us lawyers, we face this every day, day in and day out. We don't know what will happen tomorrow. Nobody ever knew what will happen tomorrow, but there was a certain predictability to each case and the outcome. Today there is no outcome. The same, with all due respect, sir, the same courts are refusing to follow their own judgments. It is not that the brother judge is not following, the same judge is not following their own judgments. So even if we were to tell our clients this will happen, you have to hedge it 10 times. That there are these other 10 outcomes also which are possible. And I think that somewhere that is taking away the trust which the client has, or the faith which the client has in us.
I just want to make one comment. I mean, I have a completely different opinion on what she has said, I mean, with highest respect. And it has happened with me, and I've experienced that when I was arguing before Delhi High Court, and I would not take the name of the judge. She pronounced the order in one of the petition, and there was a batch of 50 petitions which were coming after 10 days. And when I appeared before her, she said that, Mr. Rastogi, I've already decided on this issue. Now nothing can happen. I mean, and I requested her, and I said that, my ladyship, at least the arguments which I need to put forth, let those arguments be placed on record, because in any case I'm going to Supreme Court against this order. So she said, okay, I will hear you, but not like more than 5-7 minutes. She heard me, and I said that if on that particular day, a particular aspect of interpretation was not taken as an argument before the ladyship, I have all the right today to take that argument. Within 3-4 minutes, she understood that there was an important element of interpretation which was completely missed. Now, she's in a fix because she wants to pass a decision in my favor. And after 5 minutes of my further argument, she's asking me that, do you suggest a way out now? What's the escape route? Because she knows that she has committed a mistake. And I said that if the mistake has been committed a couple of weeks back, there is no reason that it must be committed today again. She heard me, she noted the arguments, and she deviated from her own judgment which she delivered 2 weeks back. So sometimes it is a reality that, what she's saying, maybe, it may be relevant or most relevant in 90% of the cases, but few times there could be situations where the argument which has happened has not touched on that particular aspect, either in terms of legal aspect or on the facts. And hence, there are such situations where even the same bench would deviate from its own order. Thank you.
One question, sorry. Thanks. Justice Joseph, a question for you. You spoke of eternal vigilance. Nani Palkiwala said, eternal vigilance is the price of liberty. I wish I could have asked him this question. Unfortunately, he's not among us. That what does eternal vigilance mean? Would you say eternal vigilance means eternal vigilance of the elected representatives, eternal vigilance of the judiciary? How does eternal vigilance translate to all ordinary people? And that is because that's the only thing that upholds democracy, upholds liberty, and so many things that the Constitution, the Supreme Court has to uphold.
Eternal vigilance on the constitutionalism of the executive, of the legislature, of the judiciary. If these three branches function in accordance with the Constitution, understanding what the Constitution has meant for them, and understanding what the Constitution expects from them, there's no problem. Now the problem is that, suppose we were using the word overreach. Suppose we take the role, judiciary takes the role of executive, take example. So when we say, no, it's not overreach, but actually reach. I sometimes say it's only reaching, not overreaching, because you are not reaching, I'm reaching. That is how we justify it always. So we have, it's actually, we don't have a written separation of powers. But ours is a stronger by silence. What is actually, because we mutually respect and protect the separate regions of our own occupied fields. So in that, if we respect each other and protect our self-respect, then there is no problem. This, what it has affected the self-respect of all these three branches is actually the credibility is lost. Not only of the judiciary, credibility of the executive is also lost, because they trend into so many other things also. Executive, the credibility of the legislature also is lost, because I just mentioned earlier, there's no debated legislation. You think about the legislative process now. Which legislation in the last, except for GST, which legislation in the last 10 years has come as a debated legislation? One came, that was NJCB struck down also.
So,
Because that was inconvenient for them, they wanted to make a convenient one.
Honorable Mr. Justice Joseph, on behalf of SCORA, I must express our sincere gratitude for graciously stepping it at a short notice and chairing this session in place of Honorable Justice Chandorkar, who had to leave early to catch his flight, actually. Your Lordship presence brought calm, dignity, and warmth to the proceeding. As always, it was in the courtroom, sir. And your compassionate observation has added a distinctive depth to the discussions. You are really a thought-provoking, as always. And we all loved listening to your heart, which you have expressed it in a form of extempore. We have seen that, sir. And we also like to thank our panelists, the exceptional person, Mr. Shadhan Farasa, Senior Advocate, who is known for matter at the intersection of the constitutional and regulatory law. Mr. Farasat is having nearly 20 years of advocacy experience with a practice spanning in constitutional, criminal, commercial, regulatory, and civil law. He begins his career in a dispute and arbitration team in Ambarchand Mangaldas in Delhi, and also worked as a legal officer with the African Development Bank in Tunisia before returning to the full-time litigation in India. He is particularly known for the matter at the intersection of criminal law with the commercial regulatory dispute and constitutional question, and has argued important cases including issues relating to powers of the state to regulate industrial alcohol, the challenges to the electoral bond scheme, and reservation subcategorization matters before the constitutional bench. Outside work, he enjoys playing hockey and squash. I must say, sir, that you bring the rare combination of the constitutional depth and the regulatory crossover practice, exactly what we needed for this very topic of the public policy. We are also thankful to Ms. Shali Bhasin, partner at Shadul Amarchand Mangaldas, bringing the perspective of the complex regulatory and policy implementation. Ms. Bhasin is a partner and a presence adds the practitioners and law firm advisory lens to the policy shaping how regulatory design is experienced by the market institution and litigants. What kind of regulatory disputes ultimately reach to the constitutional courts? I must say that your presence has brought the regulatory to the boardroom, to the courtroom perspective to this discussion. Mr. Abhishek Rastogi, widely recognized for the constitutional work in fiscal, tax and regulatory domain. Mr. Rastogi is a practicing advocate before the Supreme Court and various High Court and tribunals and is known for articulation and presence of mind in court. He previously served as a senior equity partner with the Khaitan and Company and has overall experience spanning 22 years with the Ernst & Young, the PricewaterhouseCoopers and the Khaitan and Company before starting his own chamber in the year 2022. He is a commerce graduate from SRCC and a member of the Institute of Chartered Accountants of India and is widely associated with the constitutional litigation in tax and fiscal issues, FEMA, PMLA investigation, real estate disputes and personal rights and liberties. He has argued a wide range of constitutional matters including GST, PMLA issues and multiple fiscal policy questions. And his work has led to corrective amendments by the state governments and the central government in some instances. He has received multiple professional awards appear frequently on business news platforms as well, and has authored several commentaries and books on tax and allied areas. I would say that, sir, your presence has brought a real fiscal and constitutional lens for our whole session. So I would now request for a small token of respect for our esteemed speakers, and I would request I would request Mr. Vikas Verma to we have a bouquet. Yeah, we have a bouquet, please, sir. Sir, bouquet. To actually felicitate Honorable Justice Joseph for his esteemed presence. I would request Mr. Kumar Mihir to felicitate Senior Advocate Mr. Farasat with a memento. I would now request Ms. Jyoti Rani, DGM Legal, to please felicitate Ms. Shelly Bhasin. I would now request Ms. Neha Rathi, Advocate on Record, to please felicitate Mr. Rastogi. I am really grateful everyone, especially to Honorable Justice Joseph. And we are having a group photographs on the lawn at 2:15. So post lunch, I would request everyone to just please be there for a group photographs as well.
You see the difference between the judge and the lawyers, na? The lawyers get gold, I get flowers. Mrs. Sasso, you want to come? Come. The backbone, please.
forgot to mention that, very good moderator. God bless you.